Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Guzman, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. It's a long and somewhat heartbreaking week for non-citizens, but such is Supreme Court season these days. Surely I don't need to tell you all about the Biden administration's announcement that they will be implementing a parole program for certain spouses of U.S. citizens, do I? The implication there being that it will allow thousands of U.S. citizen spouses to adjust to LPR status in the United States. Collaterally, then, that will take off a significant burden of adjudicating other applications by USCIS and the Department of State, and will take off a significant burden from the immigration courts in conducting removability proceedings where relief is limited. The immigration bar is excited and should be, but we all know that the lawsuit is coming and that so much depends on November. Alright, enough beating around the bush, or Biden. We've got cases to discuss. First up, you know it. Department of State v. Munoz, published by the U.S. Supreme Court on June 21st, 2024. Pretty rough term for immigration at the Supreme Court, notwithstanding Wilkinson early on. The Supreme Court has overturned the Ninth Circuit on consular reviewability, or that is to say, non-reviewability. Justice Barrett authored the majority opinion, with a dissent authored by Justice Sotomayor and joined by Justices Kagan and Jackson. We did the Ninth Circuit's big important decision on this very case on episode 128. Give it a listen. We're doing it again now because the Solicitor General decided to seek certiorari. Ms. Munoz is a U.S. citizen, an attorney too, I believe. She married Luis Asensio Cordero in 2010. Luis is from El Salvador and initially entered the U.S. without authorization. USCIS approved a Form I-130 petition for him, but he can't adjust LPR status in the U.S. because Congress changed the law in 1997. He needs an inspection and admission, or parole. But the second he leaves the U.S. to consular process and get his immigrant visa, he'll trigger a 10-year bar to re-entering. A punishment completely of Congress's own making that separates U.S. citizen families, and that Congress could resolve tomorrow. There's a waiver for it, but it requires a showing of extreme hardship to a U.S. citizen or LPR spouse or parent. Children don't count. Another thing Congress could change. But thanks to the Obama administration, non-citizens like Luis can apply for that waiver before they leave the United States so they know whether they're likely to be let back in after their consulate interview. That's the I-601A waiver, currently backlogged at USCIS by many years. Luis did all of that. He got the hardship waiver, and so he left for his interview. And you can't get a hardship waiver if USCIS believes you're inadmissible for any reason other than unlawful presence. For reasons I cannot explain, the majority decision here does not discuss any of that. But it does state that in 2015, at his interview in San Salvador, a consulate officer told him that he believed he was inadmissible under I&A Section 212A3A the incredibly ambiguous inadmissibility provision that applies where an immigration officer, quote, knows or has reasonable grounds to believe that the non-citizen seeks to enter the United States to engage solely, principally, or incidentally in certain specified offenses or any other unlawful activity, end quote. It's about as ambiguous as an inadmissibility provision can possibly be. No other explanation was provided at the consulate interview, and there's no waiver for it either, I believe. So permanent exile from his U.S. citizen family without factual explanation, despite already receiving that extreme hardship waiver. Quote, but given the reason for the visa denial, even the statutory citation was more information than Luis was entitled to receive, end quote. Quite the statutory framework, Congress. Yes, explained the Supreme Court, ordinarily a consular officer who denies a visa application, quote, because the officer determines that the non-citizen is inadmissible, must provide the non-citizen with a timely written notice that A, states the determination, and B, lists the specific provision or provisions of law under which the non-citizen is inadmissible, end quote. That's I&A Section 212B1. The statute requires no explanation, however, quote, to any non-citizen inadmissible on certain grounds related to crime and national security, end quote. Ipso facto, Luis got more information, to the majority, than was even due to him under the I&A, when he was provided the inadmissible statute that he was not being let in because of. Luis guessed it was based on a suspicion that he was a member of MS-13 due to tattoos he has. Based on everything I know about the case and what came out later during the heavy litigation in the Ninth Circuit, I'm not sure how confident the U.S. government really is that Luis is or was MS-13. But in any event, of course, consulate officers do make mistakes. What to do? Ms. Munoz sued the Department of State, but the Department of State asserted that you can't sue the Department of State even if you think they make a horrible mistake that separates families forever because of the doctrine of consular non-reviewability, something that the Supreme Court made up years ago. And I don't know, if my partner was MS-13 and I thought there was any chance in the world that the government could prove it, I probably wouldn't undergo a heavy and expensive litigation. Eventually, the Ninth Circuit held that U.S. citizens like Ms. Munoz have a related constitutional right, and that when the Department of State fails to timely provide the factual basis for denying their spouse a visa, the doctrine of consular non-reviewability no longer applies. The Ninth Circuit believed that happened here, and so Ms. Munoz got all this discovery, and actually got to litigate her case a bit. And how, after all, could a non-citizen ever find out whether the consulate officer denied for some impermissible reason, like racial discrimination, as Kerry v. Din seems to allow, if they weren't provided a timely factual basis for the reason that the visa is being denied? The Biden administration chose to seek Supreme Court review, as I mentioned, and the Supreme Court here said that, in fact, Ms. Munoz doesn't even have a constitutional right to defend here. Right out the gate, no one really argues that Luis does. He is a human, yes, but as a non-citizen outside the United States, well, he doesn't really have constitutional rights. His U.S. citizen wife in the United States, of course, does. And unless the Supreme Court really turns back the clock, that still includes the right to marry the adult human being that Ms. Munoz wants to marry. Ms. Munoz does still have that right, explained the majority, but that's not the right it believes at issue. It's not really even the right that Ms. Munoz apparently asserted at the Supreme Court. She alleged, apparently, that the Department of State, quote, abridged her fundamental right to live with her spouse in her country of citizenship, end quote. But neither she, you, me, or even Supreme Court justices apparently enjoy this most desirous of rights, explained the court, which essentially narrows and cleans up the plurality opinion in Kerry v. Din, that can now be cleaned up like that because the Supreme Court's composition has changed. As is the courts want these days, it believed that Ms. Munoz could not show that, quote, the right to bring a non-citizen spouse to the United States is deeply rooted in this nation's history and tradition, end quote. Of course, that's the case with immigration broadly. Congress always has had the right to limit it, explains the majority, convincingly. even if, quote, the United States had relatively open borders until the late 19th century, end quote. But barring living with one's spouse? Well, there isn't really a history there. But the Supreme Court does go through late 19th and early 20th century racist and otherwise problematically written exclusionary immigration laws and notes that they did not have exceptions for spouses. On the other hand, Congress did favor spouses after World War II, exempting the brides of veterans from certain inadmissibility bars. But even that wasn't a blanket exception, and there's a Supreme Court case actually upholding inadmissibility for one such spouse, and making it non-reviewable at that, it seems. But a constitutional right doesn't depend on congressional legislation, right? At least that's how I learned con law. The majority isn't saying that, of course. They're just using it to support their rationale that they don't believe that the Constitution has much of anything to say about the right to live with your non-citizen spouse in this country. The majority sees the floodgates opening if it rules otherwise. If I'm reading it correctly, I believe that due process, at least in this circumstance, only matters if you have a constitutional right underlying your right to the process, and so that ends the inquiry. Ms. Munoz lost. Does that mean that you can't ever sue the Department of State for an immigrant visa denial now because there's never a constitutionally protected right at play? Like, ever? Ira thinks not, but I don't quite understand why he thinks this. But he is smarter than me. Justice Barrett's opinion is many things, but it is respectful. It also says in a footnote, quote, "To be clear, today's decision does not remotely call into question any precedent of this court, including those protecting marriage as a fundamental right," end quote. Rest easy, my multiracial and same-sex couple friends. Your fundamental right is safe for now. My parting thoughts. Kind of. As many of you know, the immigration bar really came together to file amicus briefs in this case under very tight deadlines. One of those entities was the ABA Commission on Immigration, of which I'm a commissioner, and with the heavy assistance of Sidley Austin and others. Naturally, this decision is a disappointment. This is what ABA Commission on Immigration Director Meredith Linsky had to say. Quote, "A majority of the court held that a non-citizen has no due process interest in the denial of her non-citizen spouse's visa application. The majority concluded that such a due process interest would exceed the traditional right to marriage. The majority, therefore, did not reach the issue addressed by the ABA's amicus brief, whether the consular decision provided due process. The result is heart-wrenching, considering the facts in this case, but not surprising based on what we heard at oral argument. I have thought about this family often this week, since the Biden administration announced their new family unity policy for mixed-status families. I can't help thinking that if this policy were in force when Ms. Munoz petitioned for her husband, he may not have been required to leave the country, nor subjected to the extraordinary discretion afforded the State Department in these decisions. This week, as hundreds of thousands of families rejoice at the prospect of safety and security, the Munoz family is left with little to no hope of ever living together again as a family in the United States. You may or may not know that Ms. Munoz is a U.S. licensed attorney and clearly cannot practice her chosen profession outside of the United States." End quote. Thank you for sharing, Meredith. Godspeed to the family. And that is Department of State v. Munoz. Turning then to the BIA with matter of HCRC. This case is about credibility and torture. Mr. HCRC is from El Salvador. He claimed he suffered and feared persecution and torture in El Salvador by gangs and police officers. Quote, "He testified that he stood up to a corrupt police officer and, in retaliation, and transferred to a prison for gang members. He further testified that he was beaten and raped in prison. After his release from prison, the respondent allegedly was detained twice by the police on suspicion of being a gang member and beaten and sexually assaulted." End quote. The IJ apparently had doubts about credibility, but the IJ believed himself or herself bound by circuit precedent, and begrudgingly found Mr. HCRC credible. But still, the IJ questioned whether Mr. HCRC was actually sexually assaulted. Quote, during the hearing, when addressing whether the respondent had been tortured in the past, the immigration judge said that rape may not be pleasant, but it's not torture, and stated that rape in prison by gang members is not torture because he's in prison for having committed a crime. It's a lawful sanction, end quote. In a footnote, the BIA recognizes that just what the IJ is deeming a lawful sanction is a bit unclear. But, well, the BIA is not going to let that grenade get to the circuit and remanded. First, the BIA clarified a bit what must be done to be deemed credible in immigration court. A bit oddly, under Garland v. Dye a few years ago, while, quote, the lack of an explicit adverse credibility determination affords the respondent a rebuttable presumption of credibility on appeal to the BIA, end quote, the same is not true for the IJ. The IJ can credit some but not all of a non-citizen's testimony, be it because it's implausible, internally inconsistent, or other things. That's per statute. Quote, if the immigration judge finds the respondent not credible, that finding must be supported by specific and cogent reasons, end quote. Not only that, even when blessed with credibility, explained the BIA, quote, we need not find the evidence persuasive or sufficient to meet the requisite burden of proof, end quote. Threading the needle. Again, though, relying on Dye, quote, it's not always the case that credibility equals factual accuracy, nor does it guarantee a legal victory, end quote. All that being said, the BIA held here that the IJ did not make sufficiently, quote, comprehensive findings of fact, end quote, sufficient for it to review. Quote, the immigration judge erroneously determined that legal precedent compelled him to conclude that the respondent testified credibly. However, no statute or legal precedent compels an immigration judge to conclude that a respondent's testimony is credible, end quote. Further fact-finding needed then on credibility, including also on the issue of a particularly serious crime, and so it was remanded. So too on cat protection and that rape stuff. Flat out, quote, rape clearly rises to the level of torture, end quote, and can never be a lawful sanction, explained the BIA. Quote, while incarceration is a lawful sanction, rape by fellow inmates is not, end quote. And in any event, quote, a lawful sanction cannot defeat the object and purpose of the Convention Against Torture to prohibit torture, end quote. I like that broad quote. Yes, I do. Further fact-finding needed there too, assuming it happened, as to the motivations of the rapers and those who put Mr. HCRC in that situation. Such is life and the analysis required of us immigration attorneys and the judges and attorney advisors who must read our briefs. Not only that, and while again recognizing that the IJ might not have meant all that unfortunate stuff, the BIA remanded the matter back to a different IJ, quote, to avoid any appearance of unfairness, end quote. All of it gives me the ick, as my Gen Z sister-in-law would say. And so, congratulations Nancy Oretskin for respondent. And that is matter of HCRC. Moving on to Garcia Cortes v. Garland, published by the Fourth Circuit on June 17th, 2024. This case is about exceptional and extremely unusual hardship for non-LPR cancellation of removal. And, quote, in line with Supreme Court practice, this opinion uses the term non-citizen as equivalent to the statutory term alien, end quote. Citing Justice Kavanaugh and Barton v. Barr, all the way back on episode 1 of the podcast, and rather than Justice Alito in Chavez v. Garland last week. Ms. Garcia Cortes is from Mexico and has lived in the United States for 20 years and applied for asylum 14 years into that, which was denied, thereby resulting in removal proceedings. Interesting strategy, and hopefully not the nefarious kind. In those removal proceedings, Ms. Garcia Cortes applied for relief from removal in the form of non-LPR cancellation of removal under I&A Section 248B, something only available in removal proceedings. That relief requires, in addition to 10 years continuous physical presence in the U.S. and other things, that the non-citizen's removal will result in exceptional and extremely unusual hardship to a U.S. citizen or lawful permanent resident spouse, parent, or child, under 21. Here it was Miss Garcia-Cortez's 14-year-old daughter. A therapist letter was submitted showing that she would, quote, experience severe emotional distress and be at increased risk of self-harm if Miss Garcia-Cortez was removed, end quote. The letter was apparently detailed, and there was, quote, extensive testimony, end quote, on these issues. But the IJ did not believe it severe enough. The IJ also said it was, quote, somewhat ironic that Miss Garcia-Cortez would be attempting to assert any hardship to her daughter based on a situation of Miss Garcia-Cortez's own making, end quote. The BIA affirmed by split decision, taking explicit pains to avoid that last rationale. The Fourth Circuit remanded by split decision. Good thing about Wilkinson from the Supreme Court this term, or maybe none of it gets reviewed. They weren't all bad out of the Supreme Court this term. Although it seems like the Fourth Circuit was already applying a Wilkinson-like rule before the Supreme Court issued that decision this term. In any event now, uncontested facts can be reviewed by the Circuit Court to see if they meet the legal standard of exceptional and extremely unusual hardship, said the Fourth Circuit in a few pages. So the Fourth Circuit reviewed it, and affirmed the IJ and the BIA, actually. Case law holds that the required hardship for non-LPR cancellation is, quote, substantially beyond the ordinary hardship that would be expected when a close family member is removed, end quote. Both the Fourth Circuit and BIA have held that various forms of psychological harms to U.S. citizen children is A-OK under immigration law and won't enable a parent to stay. In line with that here, the immigration judge found that the minor child is doing well in school, has mental health conditions that are resolved or being managed, has trouble sleeping, is not prescribed medication except melatonin, would lose her mother's insurance, which currently pays for therapy, but could get Medicaid, would continue to be financially supported by her father after the mother's removal, and would be able to live with her brother and remain in a supportive, close-knit family. Quote, while substantial, end quote, explained the court, these hardships are something immigration law can live with, now that Congress got rid of suspension of deportation in 1997 and left only non-LPR cancellation for people such as Miss Garcia-Cortez. As an aside, the Fourth Circuit is not sure whether to apply de novo or abuse of discretion review on these facts, given the Wilkinson Court's somewhat ambiguous discussion of the proper standard of review, depending on how factual the inquiry is, in a mixed question of law and fact. A complicated issue for another day, explained the Fourth Circuit. But anyway, that means that the IJ and the BIA weren't wrong, or that is to say, wrong enough. But the Fourth Circuit continued, circuits may also consider whether, as required of the regulations, an IJ, quote, considers all evidence placed before him, end quote. And this, the IJ and the BIA did not do. Specifically, quote, we are unable to conclude that the IJ considered all material portions of the therapist's letter as was required, end quote. Now true, the IJ said he read the letter and considered the letter, and indeed, the IJ discussed the letter throughout his decision. However, quote, despite clearly having considered portions of the therapist's letter, the immigration judge never addressed the therapist's expert judgment about how Miss Garcia-Cortez's removal would impact, end quote, the daughter. That is the ultimate conclusion, something that experts are allowed to testify to. That's a pretty important part, particularly where self-harm is discussed. Nor then did the BIA sufficiently proper consider the therapist's letter, which I don't know if it could have done anyway, given that the IJ likely did not. The Fourth Circuit doesn't see similar errors or omissions with other pieces of evidence, as Ms. Garcia-Cortez argued on petition for review, but the therapist's letter thing is good enough for a remand to 2 of the 3 judges. Important decision, and maybe the first, to really start diving into what type of review is permitted or required post-Wilkinson. Mark it, especially Fourth Circuit folks. Judge Rushing dissented for a few reasons. But it all means, congratulations Zinzi, Kloiba, Corbett, and J.S. Marks for petitioners. And that is Garcia-Cortez v. Garland. Next is Rosales-Mendez v. U.S. Attorney General, published by the 11th Circuit on June 20th, 2024. It's the first true in absentia reopening case involving a deficient NTA post-Campos Chavez. Kind of. Ms. Rosales-Mendez is from Honduras and entered the United States without authorization 24 years ago. Shortly after entering, she was served with a notice to appear that did not tell her the date and time of her first removal hearing. She was actually caught by border officers while trying to get on a plane in Texas to go to Miami. Now, it appears that Ms. Rosales-Mendez told officers that she'd be living at her boyfriend's address in Miami, but she didn't know it yet when she was apprehended. So she actually had border officers call her boyfriend to get the address in Miami, which is kind of wild. But according to the 11th Circuit, the boyfriend messed up. He forgot to provide the directional designation of Southwest in the address. Unsure how that's known 24 years later, but that's what the decision says, and the address reflected in the NTA and used in the follow-up notice of hearing was therefore sent to the wrong address. Perhaps this is why Congress wrote a statute requiring the date, time, and location of the first hearing to be in the NTA, rather than having everyone have to rely on follow-up notices of hearing that could be mailed to incorrect addresses. Just a thought. 7 months later, the notice of hearing was mailed. It was never received. Ms. Rosales-Mendez didn't show up, and she was ordered removed in absentia in 2001. She moved to rescind and reopen right after Pereira, it appears. That motion was denied. She would have likely won this case had Chavez come out the other way last week, and with some sympathetic facts to boot. But Chavez did not come out the other way. And I'm not going to lie, I cannot for the life of me understand why the 11th Circuit published this decision and did not cite to Chavez once, and yet, practically speaking, reaches pretty much the same holding. I have a feeling it was written before Chavez was issued, and then amended. So maybe it's because the 11th Circuit wanted to go a little further. It held that ICE and EOIR are, quote, exempt from providing notice altogether, end quote, if a non-citizen makes a mistake and then does not correct that mistake in the address provided to ICE and placed in the notice to appear. After all, DHS's own regulations, quote, clarify that the non-citizen's obligation to provide the government with her address includes the obligation to correct any errors in the address listed on her notice to appear, end quote. So there's that, an agency regulation. Quote, by failing to correct her address after being apprised of her obligation to do so, Ms. Rosales-Mendez forfeited her right to actual notice of her removal hearing, end quote. This follows, explained the court, from its Drago-Morescu decision 2 years ago, where that non-citizen, also with a deficient NTA, moved addresses and failed to notify the immigration court. And yes, here we are at my all-important question from the beginning, left for the end of the decision, but really, the factual issue that this decision rises or falls on. Quote, last, Ms. Rosales-Mendez argues that the notice exception does not apply because the government cannot prove that she, through her boyfriend, provided the wrong address. It is far more likely, she says, that the agent recorded it incorrectly, end quote. Whose fault was the exclusion of the all-important SW language from the address placed in the NTA? Yes, what about that? Well, the BIA held that it was the boyfriend who provided an incorrect address. God knows how the BIA concluded that 20 years after the fact, but they did, and the 11th Circuit doesn't believe that it compels reversal. Seems like Ms. Rosales-Mendez was less than completely certain in her affidavit, though, which, to be honest, is expected, and in any event explained the court she had the burden under the regulations to correct the mistake. No reopening despite the NTA only being a, quote, putative notice to appear, end quote, to the 11th Circuit, and notwithstanding the clearly clerical error. And that is Rosales-Mendez v. U.S. Attorney General. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. We return with Inestroza-Tosta, the Attorney General of the U.S., published by the Third Circuit on June 21st, 2024. The Third Circuit has entered the dispute about when and whether it has jurisdiction to review denials of withholding of removal and Convention Against Torture Protection post-reinstatement, when the 30-day deadline to petition for review begins under such circumstances, and whether, post-Santos-Zacaria, it's jurisdictional at all. Hint, hint, they're all good legal rulings for the non-citizen. Another amicus win on this complicated and important issue from Kristen McLeod-Ball and Trina Realmuto from NILA, as well as Anand V. Blakrishnan from ACLU and Cheryl Lynn for petitioner. But it was ultimately a loss on the merits. Sigh. I've talked this very complicated legal issue to death recently, and it's a long week. I refer you back most recently to FJAP v. Garland, published by the Seventh Circuit in episode 201. But I can't help myself, so here we go. Mr. Inestroza-Tosta is from Honduras, was removed in 2006, unlawfully re-entered, and had that final order of removal reinstated. Twice, actually. Most recently in 2021 after a New Jersey aggravated assault charge. But in his defense, it was New Jersey. He claimed to have a fear of return. Found to have a reasonable fear, he was placed in withholding-only proceedings. And actually, he was also pursuing a U visa as a victim of crime who had helped police investigate or prosecute a crime, in his case, a violent attack that he had suffered in New Jersey. The immigration judge continued withholding-only proceedings 4 times to try and await a resolution of that, and once for technical reasons. But eventually the court went forward, and the IJ refused to administratively close withholding-only proceedings to await adjudication of the U visa matter. The IJ then denied Mr. Inestroza-Tosta's gang-based withholding of removal and CAT claims. The BIA dismissed the appeal. You have to petition for review to the circuit within 30 days, and Mr. Inestroza-Tosta did that. But if the 30 days began to run when his initial removal order became final in 2006, well, then he can't get review at all of the withholding and CAT denial here. So too, if the 30 days began to run when the old removal order was reinstated, he's well over the 30 days, because that happened in 2021. And even worse, if it's jurisdictional, there's no possible exception. But that's all absurd, says I. Not says the Second and Fourth Circuits, I believe, based on an aggressive reading of the Supreme Court's Nasrallah decision, but says I. And says the Third Circuit. First, the 30-day rule to petition for review isn't even jurisdictional. It's a claims processing rule. That's a bit new and flows from the Supreme Court's Santos-Zacaria decision last term. In so holding, the Third Circuit expressly overruled its prior precedent. From Santos-Zacaria, and in a quote that I'm already using in briefs because it is just so excellent, quote, "We are to treat a rule as jurisdictional only if Congress clearly states that it is, with ambiguity leading to the conclusion that the rule is non-jurisdictional," end quote. Not so here with the 30-day rule to petition for review, and honestly, not with a lot of the INA's once believed jurisdictional statutes. Lots of additional analysis as to why that I advise you poach from in your circuit and district court briefs. Or perhaps email Trina for her briefs. Really getting into the weeds here, the Third Circuit believes that Santos-Zacaria, quote, all but abrogated Stone v. INS, end quote, a prior Supreme Court decision, so remember that if oil cites to Stone on jurisdictional issues. And all of this explains the Third Circuit aligns with recent decisions out of the Ninth and Fifth Circuit, both discussed on the podcast previously. I don't recall any circuit actually affirmatively holding otherwise yet, although the Third Circuit believes that the first footnote in Salgado v. Garland out of the Fourth Circuit, episode 162, might have created a circuit split on that issue as well. That is, whether the 30-day rule to petition for review is jurisdictional rather than a claims processing rule. But you already got a gong in this case, and that was just a footnote. Although in fairness, my notes show that I did bullet, quote, 30-day jurisdictional requirement, end quote, when I did Salgado. So there you go. The Third Circuit doesn't say, though, whether the claims processing rule is mandatory, or rather, can be equitably tolled. For the next case. Kinda unnecessary discussion, though, unless I'm missing something, because the Third Circuit then holds that the petition for review was timely filed here, having been filed 30 days post-withholding of removal denial by the BIA. That's definitely a circuit split with the Fourth and Second Circuits. Oil's no longer arguing otherwise in these cases, explained the Third Circuit. The court nevertheless goes on to analyze Guzman Chavez and Nasrallah like many courts before it, and concludes that, quote, the final ruling on withholding of removal is a judicially reviewable final order of removal to a non-citizen subject to a reinstated order of removal, end quote. Indeed, to hold otherwise would mean, quote, judicial review of those proceedings would be impossible for non-citizens with reinstated orders of removal, end quote. And that can't fly for a litany of reasons, explained the Third Circuit. I still think it's going to the Supreme Court next term or the term after. Next, the Third Circuit did not see error in the IJ's refusal to administratively close to await the U-visa stuff, or the BIA's affirmance of that, even if the BIA apparently did not consider every matter of Att'y factor. But hey, admin closure's back, guys, right? But then, as I mentioned, Mr. Inestroza-Tosta lost on the merits. I've already gone on longer here than I wanted to, but suffice it to say, the Third Circuit agreed that, quote, gang violence recipients, end quote, is not a legally cognizable particular social group because it is, quote, defined exclusively by the fact that its members have been subjected to harm, end quote. Too circular. Although recent precedent out of the First Circuit, if I'm not mistaken, would counsel against a holding that a particular social group is not cognizable simply because harm is referenced in the definition. But to the Third Circuit, quote, persecutory conduct alone cannot define a particular social group, end quote. And actually, in a footnote, the Third Circuit recognizes that its 21-year-old precedent in Lukwago v. Ashcroft holds similarly to what I believe the First Circuit recently held, that, quote, the shared experience of enduring past persecution may, under some circumstances, support defining a particular social group for purposes of fear of future persecution, end quote. So there you go, something to remember. But that's not what was happening here. In this case, the purported particular social group was all about the risk of harm, said the Third Circuit, and Mr. Inestroza-Tosta didn't otherwise establish social distinction, said the court. Also to the Third Circuit, nothing in the record apparently indicates that Mr. Inestroza-Tosta was attacked by MS-13 in 2007 for the reason of his membership in this alleged particular social group. Speculation, said the court. Deeming Convention Against Torture Protection waived, but at least reviewing withholding of removal, the Third Circuit denied the petition for review. And that is Inestroza-Tosta v. Attorney General of the U.S. Concluding with two from the Ninth Circuit. First, Gonzalez-Lara v. Garland, published by the Ninth on June 17, 2024. This case is about asylum. Miss Gonzalez-Lara is in her 20s and from a part of El Salvador that is controlled by the 18th Street Gang and MS-13. She had scary run-ins with the gang throughout her life and then in 2017 began to date a police officer. They dated for 5 months. The officer said that they should date in secret because many police officers and their families had been killed by the gangs. Also, Miss Gonzalez-Lara's own cousin was likely an MS-13 leader. Really terrible stuff. Rumors began to thread about Miss Gonzalez-Lara and her involvement with the police. While they dated, Miss Gonzalez-Lara's cousin was killed in jail, likely by the rival 18th Street Gang. Miss Gonzalez-Lara feared that she'd be targeted next. All the while, she's got this relationship with the cop, and she becomes pregnant. She started receiving warnings about her relationship with him and apparent threats, and decided to flee to the United States, pregnant, in December 2017. Served with a deficient notice to appear, Ms. Gonzalez-Lara was placed in removal proceedings to bring her asylum claim based on her relationship to the police officer, her cousin, and an anti-gang political opinion, and as a member of the particular social group, Salvadoran single women. The immigration judge didn't believe any of them were reasons for her fear, and that in fact she didn't have an objectively reasonable fear at all. The BIA affirmed. The BIA also declined a remand as Ms. Gonzalez-Lara had alternatively requested, for her to apply for post-conclusion voluntary departure. See, after the immigration judge ruled, the Ninth Circuit issued Pozo-Sanchez v. Garland, episode 63, which held that the stop time rule keeps running for post-conclusion voluntary departure where the NTA is deficient. That meant that by the time of the BIA appeal, or maybe sometime during it, Ms. Gonzalez-Lara got the years in the U.S. required for post-conclusion voluntary departure, because they continued to tick with the deficient NTA. The BIA refused to remand, though, holding that Pozo-Sanchez doesn't apply to non-citizens like Ms. Gonzalez-Lara, who hadn't requested voluntary departure before the IJ the first time around, even though she wasn't eligible for it during the IJ proceedings and until Pozo-Sanchez was issued. In any event, reasoned the BIA, Ms. Gonzalez-Lara hadn't established her prima facie eligibility for the relief, which isn't very hard, but also it is a showing. Nor explained the BIA was termination of removal proceedings warranted. The Ninth Circuit affirmed, although not before cleaning up that first voluntary departure holding. First, explained the Ninth Circuit, non-citizens need not seek post-conclusion voluntary departure when they were clearly not eligible for it to benefit from Pozo-Sanchez when Pozo-Sanchez was published after the IJ proceedings. And I guess so too with other changes of law that come out during appeal that totally change the relief eligibility. And, quote, a motion to remand is the proper course of action for a petitioner to submit a new application for relief, especially when that application is based on a substantial change in the law, end quote. So everything Ms. Gonzalez-Lara did here on appeal to the BIA was correct. Quote, simply put, the law does not require parties to engage in futile acts. The BIA erred in holding that Ms. Gonzalez-Lara was barred from seeking relief for which she became newly eligible while on appeal based on an intervening change in law, end quote, and a quote to remember. All the same, explained the court, as with all motions to remand or reopen for the purpose of applying for new relief, non-citizens need to establish their prima facie eligibility. Fonseca v. Garland, episode 172, tells us that isn't the most onerous requirement in the Ninth Circuit, and really anywhere because of matter of log, but it's still something. For post-conclusion voluntary departure, the elements to meet are, to paraphrase, that you've been physically present in the U.S. for a period of at least 1 year, although a 239A1 compliant NTA stops that 1 year from ticking. Is and has been a good person of good moral character for at least 5 years immediately preceding the application for voluntary departure, is not deportable under certain removability provisions, and has established by clear and convincing evidence that he or she has the means to depart the United States and intends to do so. At a minimum, Ms. Gonzalez-Lara didn't provide any financial information, so that final element can't even be prima facie shown. But hey, Ms. Gonzalez-Lara probably would rather remain in the U.S. anyway, right? Hence her asylum claim. But the Ninth Circuit saw no error in the agency's denial. Her fear of harm was too speculative, explained the court. She, quote, did not present evidence that the gangs have shown interest in her, her former partner, or her family since she left El Salvador in 2017, end quote. And she herself was never harmed in El Salvador. Pretty short analysis. This case was probably published for the voluntary departure stuff. Convention Against Torture Protection was denied as unexhausted, and so Ms. Gonzalez-Lara lost her case. And that is Gonzalez-Lara v. Garland. We conclude with United States v. Rivera-Valdez, published by the Ninth Circuit on June 17, 2024. It's a very long and complicated one that technically arises in the illegal reentry criminal context, and which I did when I thought it was going to be a much shorter week. It's issued per curiam, meaning simply that it's the opinion of the panel rather than a given judge. Except Judge Bumate concurred, as did Judge Baker by separate concurrence, and then Judge Sanchez dissented. So this is most definitely not the opinion of the panel. The whole thing is a bit strange, and possibly something of interest to an appellate process nerd. There's got to be one of you out there. So here's what the 10-page actual per curiam decision said. Still complicated, and it's about deficient notice. Mr. Rivera-Valdez was ordered deported in absentia 30 years ago because he didn't show up for his deportation hearing. So it's pre-IRIRA, meaning pre-NTA, meaning the deficient NTA stuff doesn't even really apply at all. He was physically deported as a result many years later, but he returned and was charged criminally under 8 U.S.C. Section 1326. His federal public defender argued that 1994 deportation order violated his due process rights, meaning that the district court judge needed to dismiss the criminal indictment. The district court disagreed, and 2 of the 3 Ninth Circuit judges here affirmed, in unison, but also with separate concurrences. Interesting background. Let's get into it. Mr. Rivera-Valdez filed a fraudulent asylum application with INS in 1993, shortly after he first entered the U.S., stating that he was Guatemalan, but he's not. He probably did that, if I'm not mistaken, and I might be mistaken, because the ABC settlement was around that time, which allowed certain Guatemalan and Salvadoran nationals to apply or reapply for asylum. Just a guess. I wonder if a notario was involved and whether Mr. Rivera-Valdez even knew what he was signing. In his asylum application, Mr. Rivera-Valdez listed a certain address in Portland, Oregon. The asylum receipt was sent to that address, as were notices approving Mr. Rivera-Valdez's work authorization. He, quote, presumably received notice of the work authorization approval because he showed up at the local INS office to pick it up on March 3rd, end quote, where he presented a false Guatemalan birth certificate. So I guess he knew. But it was the old switcheroo. INS didn't give him the work authorization card and instead served him with an order to show cause for the deportation hearings that they had just initiated. That OSC, however, did not have the date of the hearing that he was supposed to appear at in it, despite there being a place to insert that date in the OSC. Now, there's already precedent that holds that all of the deficient NTA stuff doesn't apply to orders to show cause. And textually that makes sense, as there wasn't a similar statute defining exactly what must be in an order to show cause, I don't believe, as there is for NTAs with INA Section 239A1. But I mean, due process would seem to require that a non-citizen be provided the date of the hearing in the document that they're being served with initially, and that initiates proceedings as serious as deportation ones, no? That's what Mr. Rivera-Valdez argued. That follow-up notice of hearing was sent to that Portland address, but Mr. Rivera-Valdez did not appear. The hearing notice was returned as non-deliverable. Similarly with the next attempt at notice sent via certified mail by the immigration court. The standard here is criminal, making it immigration adjacent, but of course it's immigration relevant. To succeed in getting an indictment like this dismissed by collaterally attacking the underlying deportation order, the defendant must show that he exhausted his administrative remedies, that the deportation proceedings improperly deprived him of an opportunity for judicial review, and that the deportation order was fundamentally unfair. In the Ninth Circuit, at least, quote, a deportation order is fundamentally unfair if the defendant's due process rights were violated by defects in the underlying deportation proceeding, and the defendant suffered prejudice as a result, end quote. Not met here. Under the old statutory regime, service of a deportation notice or notice of hearing by certified mail created a rebuttable, quote, presumption of proper delivery, end quote. And old case law establishes that that is all okay. If Mr. Rivera-Valdez moved, he didn't update INS here, despite being warned that he had to when he was served with that incomplete order to show cause. Very smart counsel argued that this precedent and statutory scheme is unconstitutional, given more recent Supreme Court precedent, Jones v. Flowers from 2006. There, after all, after 2 notices regarding an imminent tax sale of a home that were returned to the state as unclaimed, the home was sold by the state. The Supreme Court said that given the significant interest at stake, that is, losing a home, quote, the state should have taken additional reasonable steps to notify the homeowner, if practicable to do so, end quote. So might not permanent exile be equally significant to losing a home? No. First, there are no cases applying Jones's, quote, additional reasonable step, end quote, standard in the immigration context, and this panel isn't going to be the first. And in any event, it seems the panel does not believe in absentia deportation as significant as losing a home, or at least, the contexts are sufficiently distinguishable. Quote, a non-citizen who has unlawfully entered the country has obvious reasons to avoid appearing for a deportation hearing, unlike a property owner who has no reason to ignore an imminent tax sale. End quote. Plus reasoned the majority, what else could INS have done? Lots of concurri and dissent, as I mentioned, including a whole chart listing the amount of in absentia removal orders from 1996 to 2024, apparently equating to 1.3 million. Interesting stuff. Maybe something to review in the future? I don't know, though. Nearly 160,000 in absentia orders in 2023? Even assuming 700 IJs, that's 228 in absentia orders per IJ in 2023. And of course, we need to take out all the detained IJs dealing with detained cases, so I don't know, like 400 to 500 in absentia orders a year per non-detained IJ? There's no way. Methinks that the stats are off a bit. And of course, not statutorily or constitutionally relevant. And that is United States v. Rivera-Valdez. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.